And as I announced to you earlier, very thankful to be joined in the studio by Godwin Ejay Jemfi. He is former senior prosecutor at Crown Prosecution Services UK, the UK state agency prosecuting Nayele Ametefeh. And so we are very privileged to have him to share with us some insights into how they deal with some of these matters. Godwin, thank you very much for coming to Newsfile.
I must say thank you very much for having me on Newsfile.
Good to have you. Now, first things first, we are told that she's picked up at Heathrow by custom and the border officials. What normally would lead to, you know, such swift action?
Well, first and foremost, let me just say that I'm purely speaking from a role as an expert in prosecuting.
That is so.
And therefore, I cannot comment on any individual cases that I dealt with whilst I was employed by the agency, because I'm still bound by certain ethical codes and conduct. So what I can actually do is to take you through the matrix in which a suspect arrested at the port of entry will go through at that early stage up to the moment of, up to the point of trial and sentence.
Okay, so if we may start this way, type A drug, what is it? That's what she's accused of carrying.
We have categories of drugs from A, B, and C. A is regarded as the most serious form of harmful drugs on the streets of London, namely crack, cocaine, and heroin. Yeah. Now, basically, when a person is stopped at the port of entry, the immigration service will get involved. The first thing that the immigration service will do is that, acting on suspicion or tip-off, they will then apprehend that person, take the person for medical examination to determine whether there is some sort of substance in the inner part of the body. That medical examination will be done even if there was or has been substance found in the outer part of the body, such as a handbag or suitcase. And the basis of that is to establish the nature of the substance, and secondly, to use it as a basis of an arrest. And if the substance does turn out to be drugs, obviously she'll be asked preliminary questions and so forth. And from that point, the notes or the information gathered by the immigration service will be given to members of the Metropolitan Police. Yeah. And at that point, the police will obviously make a formal arrest. Now, under UK law, a person can be detained at a police station for 24 hours without charge should the police require further time to conduct investigation. They will apply to somebody who is not less than a rank of a superintendent to extend that 24 hours to 36 hours. If further time is required... They don't need a
court order?
No, they don't need a court order at this juncture. Now, once that 36 hours has expired, they then have to apply to a magistrate for an extension up to 96. And from my decade of experience, the police seldom, the police always, should I say, succeed in those endeavors. So they will then carry out a tape-recorded interview of the suspect in the presence of the suspect's solicitor. Now, normally, she'll be asked, or he will be asked, questions. Now, in a very complex case, the defense lawyer would want to play it safe. We want to play it safe.
Before you get there, tell me this. At what point does the defense lawyer come in? Are they able to interview or interrogate the suspect when the lawyer is not there?
No, they cannot in serious cases unless the suspect decides on his or own accord, I want to get the interview over and done with. But that's very risky.
Okay.
Anyway, back to the process. The suspect will be interviewed in the presence of his or her solicitor. And very often in complex cases, the defense solicitor or lawyer will want to play it safe by telling the suspect to answer no comment to all the questions asked. They will then issue a statement. A statement will be written by the lawyer of the suspect, and that statement will be given to the prosecution, and it will form the basis of the suspect's case. After the interview, the file will be submitted to a senior Crown prosecutor or Crown advocate who will determine whether there is sufficient evidence upon which to base a realistic prospect of a conviction. He or she will apply independent test found in a code for Crown prosecutors. Once that evidential test has been satisfied, they will then move to consider whether indeed it is in a public interest to prefer a charge. So once those two tests have been satisfied, a charge will then be laid. And after that, the lawyer will determine the issue of bail. Now, in serious cases such as importation, I have never known in the last almost 10 years of a person being granted bail after the interview.
In Ghana, by law, there's no bail for this. So,
absolutely,
right.
In the UK.
Right. Now, tell me this, and don't feel that I'm pushing you too fast forward to the issue, but we'll take it slowly. Tell me this. She's looking to 15 years, correct?
You're talking about sentencing.
Correct.
Now, sentencing is basically two stages. First and foremost, we have to determine, or the court will determine the first step, which is determining how culpable and the role played by the person. Yeah? And that test, the court will look at, was the defendant directing or organizing production on a commercial scale?
It doesn't matter at this point that she has pleaded guilty?
Yeah, but that's important in determining sentence, whether you pleaded guilty and you're found, whether you pleaded guilty or found guilty at a trial stage. The judge must perform those mental gymnastics which I'm about to explain to you.
Okay.
So they'll also consider.
Why I'm asking is because if you're carrying 5 kilograms,
Yeah.
you get 10 years. That's the standard. And so if you're carrying 12 kilograms, we should be looking at 15. It's not doubled. Is that not the case?
Are you referring to UK law
That
or
is so.
Ghana?
That is so.
Right. Now, you see, there are a number of factors that makes up sentencing. Now, on a Class A drugs, and depending on the weight, depending on the purity, because those two elements are very, very important.
Depending on the purity of the drug.
Depending on the purity, depending also on the weight, you will be looking at double figures. But however, certain elements, factors that I was just about to explain to you, is taken into account. Now, one has to consider, was the person playing a leading role? Was the person playing a significant role? Was the person playing a lesser role? Now, I'll fast forward. In terms of determining leading role, they will consider issues like, was the person using business as a cover? Yeah? Was the person directing operations? When you move to significant role, issues such as, was the person involved in operation and management function within the chain? Yeah? They'll consider that. When you look at lesser role, they will look at, was the person coerced? Was the person doing the performing
voluntarily?
Was she doing it for financial gain?
Okay.
So once the person or the defendant has been placed within one of the categories of roles, they will then move to consider the sentencing range. Now, for Class A, as a leading role, playing a leading role, you are looking at starting point of 14 years, and the sentencing rate is between 12 and 16.
Okay.
Yeah? Now, from my experience, if you look at this individual case, and I understand that when the lady in question was stopped, she said that I have come to London for the purpose of a business and for the purpose of shopping. Now, if I was prosecuting this case, I would push her to a leading role, because obviously she was using business as an undercover, and that is one of the factors which the judge must look at in order to compute. So you have no doubt that
this is what the prosecutors presently are
that's
looking
what
at.
That's what they will be they will be pushing for, because she's not playing a lesser role. Okay. And a lesser role, you're looking at a mule, and in my experience, mules are always, one, economically challenged. They're doing it for economic gains, and there is, where they pass through at the airport is very, very significant. If you've got somebody passing through, obviously, I think what I'm being told is that the VIP section, right, it means that she cannot be a mule, she's not economically challenged, and my guess is that the prosecutor will be pushing her very, very close to the so-called Kingpin, or the supreme leader.
Right. Now, will the prosecutor avert, or prosecution, will they avert their mind to what is happening presently in Ghana, where people have been arrested and charged for abetting that crime, to which they facilitated her usage of the VIP and boarding of the plane?
Well, again, from my experience, investigation as we speak will be ongoing. They will be casting their net very wide, but at the same time, they'll be keeping a very close watch at, you know, in terms of things.
What I'm asking is, does such information help them to confirm their attempt to push that she's played a lead role, to the extent that she's had people, officials, facilitate the process for her? Yes, indeed, yes. I would say yes. I would say yes, because obviously the police would be, or the investigator will be looking even beyond the shores of the UK. Now, tell me this too. She's pleaded guilty, and she is reported to have been in a hurry, asking the judge to quickly, you know, sentence her, that she's not even interested in all the, you know, drama that will transpire. Will that have any effect in the sentencing?
Yes, it will have an effect on sentencing. And that is what we call early guilty plea. And if she were to be sentenced, she will actually get 1/3 for early guilty plea. And that will be her that will be her only, from my experience, mitigation. Because she's deprived of using a mule, the excuse of a mule, as a mitigating circumstances, because she's obviously not economically challenged. She's using VIP lounge, which means that she's mixing with the cream of the creme of within the chain of the command. Yeah, so that will be taken into account.
Do I understand you to say, because she's pleaded guilty, there's no opportunity for her to explain the circumstances which would have given the judge an idea of the exact role she played? So, to this extent, she'll be deemed to have played the lead role?
No, she will be given opportunity through her defense lawyer to explain why she undertook the role that she took, or committed the offense, in simple English, as part of the mitigating process.
Okay.
But from my opinion, having prosecuted these cases, you know, for decades, her mitigating circumstances is very limited to only early guilty plea. Because as I said to you, she doesn't fall within the scale of a mule, because she's not economically challenged. And she, on her own admission, said she came for business and to do shopping. And obviously, if the Crown have evidence of photograph of her lifestyle or evidence to that effect, obviously that will be used to push her up the scale and to deprive her of the of her saying, I was a mule, I was coerced into it, and I did it by way of in order for financial gain.
Often lawyers would advise their clients to plead guilty in certain cases. Particularly, I am familiar with asking your client to plead guilty when it's a misdemeanor and you are looking forward to plead mitigation, where you are likely to get maybe a small fine, just a caution or a simple bond, and then they go off. Why would anybody be pleading guilty for an offense where she's probably looking at, you say, 16 years?
I mean, I'm not in her mind.
No, you have been in this business of prosecuting such cases. You should have an idea.
I do have an idea, but I cannot support it with evidence. And that has always been the bane of prosecutors. I'll give you a classic example. When such a person is arrested, we are always told by the investigating officers that there is there's a human traffic to and fro the prison service. We believe, although we cannot prove it in a court of law, that the arrested person or the suspect at that stage is being influenced. So you often find that where the person has made a significant statement to the police, i.e., I'm very sorry, da-di-da-di-da, during the course leading up to the trial, it changes. And we base that change on the human traffic to the prison service.
Explain this human traffic and influence that you speak about that plays such a critical role here.
As I said to you, we cannot prove it. It's a hunch.
Yes, I'm not asking you to prove it. I'm asking you to explain to me in very ordinary terms so I can appreciate it. What human traffic is this, and what influence are you talking about?
Well, we're suggesting that at that early stage, particularly that early stage, one does not need a VO, visiting order, to visit a suspect. So one can always make a request, so long as the person says, yes, I want to see that person, the visitor is allowed. And we find that those in the course of our work, those visitors play a significant role in how the person pleads, you see, and the story that they tell. For example, let me allude you to this. According to the Matrix Knowledge Group in 2006, there is a top-down chain of authority and a strong internal discipline in the drug trafficking trade, headed by the financier or the kingpin or the supreme leader. Then you've got your number two, the producers, and then you've got the mule, i.e. the individual paid to transport the drugs across border without, with very limited knowledge.
At this time where they do not need a visiting order.
I'm leading to it. I'm leading to a point. And then you've got your warehouse keepers. Now, because of that strong authority and internal discipline, the person arrested will be lent on to sacrifice he or herself for the chain of command to exist. Sometimes it may be for reward. But as I said to you, this is something that we cannot prove.
All right. Thank you. Now, I was asking again, you say that at this point she would not need a visiting order for people to visit. So anybody at all can request she can request for anybody to visit her.
Yeah. That is prior to, I forgot to mention, prior to her charging.
Prior to being charged.
Yes.
Okay. Yeah. So normally, how does it happen? Is she the one who determines that the mission, if you are a foreigner coming into that country, is she the one who determines that the mission visits her, or it is an obligation thrust on the mission to visit any of its nationals that are found in such difficult situations?
It's an obligation, but sometimes it can be by way of request by the suspect, particularly if the suspect is does not know the system or does not have access to lawyers or relatives to actually engage a lawyer. So your first point of call will be the mission. So you can actually ask for your mission to visit you. But it's an obligation on the mission.
Mm-hmm. So that invitation is not done by the arresting authorities. It is the accused who does it. Is that it?
Now that is also open to, no, I mean, the police, once you've been arrested, will offer you what we call a duty solicitor. But they are not under any obligation to refer you to your mission, no.
Okay. They are not under any obligation to ask to call your relatives if you have, or your guests,
yes,
where you are visiting?
Yes, that is under, I believe, Section 58 of the Police and Criminal Evidence Act 1984. Yes, you have access to make a phone call. You have a right to inform somebody of your arrest, which I believe is the same as in this jurisdiction.
Okay. Just to clear that point again, the British authority, after they arrest you or put you under suspicion of carrying drugs or for whatever crime it is, will not call the mission of the visiting the accused, and will not also call his relations or the guests that person is visiting, to inform them officially that we have your national with us, or that we have your friend, or we have your guest with us?
In certain circumstances, that is done. That is done in very special circumstances.
Okay.
I mean, I used to also defend importers, particularly those from the Caribbean, and very often their relatives or somebody will call me. I've never had a call from the mission, the Jamaican mission, and I believe it may well be down to the fact that the person is insignificant, or they don't know about that person.
I see.
Unless they're tipped off.
Now, when those people come to visit the prisoner at this point, the accused person, when they come to visit, are you saying that privacy is allowed? There's no way to make sure that whatever conversation they're having it in the open, so that you can know if they are coercing the person to plead guilty and to protect the larger group interest, like you suggest?
Yes, there is maximum confidentiality. There's maximum confidentiality. But however, once a person has been charged and the person is indeed a very serious offender, that person would be allocated to a telephone at the prison service. And the purpose of allocating a special phone to that person is to continue surveilling that person. And from my experience, I have listened to telephone recordings. But in terms of face-to-face meeting with your relative or your visitor, no, there's maximum confidentiality.
Okay.
Now, we don't even know what is being said.
Okay. Now, let's look at it this way. She's pleaded guilty, which means effectively that there's no opportunity to get first-hand information as to how exactly the role she played.
Yeah, that information will be given to her lawyer through her. Her lawyer would have had, say, an hour to 2 hours consultation with her at the police station, and her lawyer will take her instructions. And that instructions will form basis of her.
That's if she intends to mitigate.
Oh, she will mitigate. There will be mitigation. A lawyer will speak in order to keep the sentence to the bare minimum.
Okay.
And then there is also a role to play in the sentencing exercise by the probation service. The probation service will visit her, and I believe that the adjournment was for sentence, and a pre-sentence report would have been ordered by the judge.
Okay.
Yeah, and that pre-sentence report will aid the judge in the sentencing exercise.
So are you saying that, for example, her attorney will be able to tell the court by way of mitigation that it is this man, alleged Dauda, who's being sought after by the Ghanaian authorities.
I'm afraid I don't know this,
No,
mate.
yes, I'm telling you, that's it. It's in public domain, it's not secret. Already there are 12 people, or we are getting to understand even more than 12, have been arrested in connection with this. Are you saying that at this mitigation plea during the sentencing, the attorney is allowed to say, look, she didn't do it alone, this person, that person, that person assisted her, and this is how the drug was brought into the country?
Yes, that is open for her attorney to say that. That is open for her attorney to say that. But you see, there is a catch here, and the catch is that if that information was not disclosed at the early stage of the investigation, i.e. at the interviewing stage, the judge will draw an adverse inference. The judge will say, the Crown can always say, look, this was never mentioned, or even the judge will say that. I've read your interview transcript, or I've read the statement you gave, why wasn't this mentioned?
And at this point, we have already crossed that hurdle. The judge obviously would have drawn an adverse inference, correct?
Yes, mentally, yes.
Okay. It is not possible that the defense will go into that court for the purpose of mitigation to tell the story of how she brought the cocaine into that country.
Yes, that is possible.
It's possible.
That is possible, yes.
So even after pleading guilty,
yes,
straight away, there's still the opportunity for the British authorities to get to know the entire operation so that she will disclose all her associates and partners. Is that what you're saying?
Look, what I'm saying is that during the point of mitigation, her lawyer will explain why she committed the offense.
Yes.
As to the detail or the matrix as to how she committed it, that's an issue for her and her lawyer.
That will not be told.
It may be told, it may not be told. Okay. But I think I believe I've been told that this person is a very high-profile person, and I, from my experience, I doubt it very much. It will be the detailed aspect will be aired in open court. There is a process called a text, whereby if the person detained wants to assist the Queen or the Crown in the investigation, they will, do it in the form of a text, which is a letter which will be secretly given to the judge. It's done so secretly that your own defense lawyer will not know about it, because in the absence of the lawyer, the person detained, whether at the police station or the prison, will be constantly visited by the investigators to try and get to the bottom of the investigation. Okay,
so supposing, like you're saying, and it's very obvious that the defense attorney will not go there and name any other accomplices or how they got the drug.
That is possible.
If that is possible, what will the UK authorities do with that information?
That information, they will act upon it. They will act upon it. They will go and see her again to try to get further details. But her lawyer, her defense lawyer, is really boxing a corner when it comes to mitigation. He or she is boxing a corner because of the fact that it's very difficult to put her within that category of a mule. It's very, very difficult, because normally mules are doing it for economic reasons. They don't have business. They don't have houses. You see, it's very, very difficult.
I was asking you that question because, the general understanding is that such persons who are known to deal in this trade plead guilty, and like you suggested earlier, and it's also in public, that they do so, and there is reward for them after they have served their sentences. But again, they plead guilty so that the opportunity to tell the story is lost.
That is so, but primarily they plead guilty to also get a lesser sentence, to avail themselves to the 1/3 discount.
Okay. Yeah. So that in all, from the way you look at it, how many years is she likely to get?
Oh, It's a very difficult question.
Give a range.
Difficult because, one, we do not know the purity.
Okay.
The purity is very significant.
Supposing that after the forensics, it is shown that the purity is the one that makes it a worse of offense.
The purity and weight, I would say she's looking at double figures. She's looking at 10 years and above.
10 years and above?
And above, yeah. I would say if I am pushed to put my head on the block, I would say the prosecutor will be aiming for or gunning for 16 years.
For 16 years?
Will be gunning for 16 years. I am not saying that's what she will get, because obviously we do not know the purity.
Okay.
Which is very significant.
So supposing that the testing shows otherwise, by way of the purity and the weight, so it will come down to say about how many years? 10 years?
I'll say about 10.
About 10 years.
10. But so the purity is high.
So the British authority
16.
is at this moment simply interested in, she's pleaded guilty, convicting and sentencing her, and that's the end of the story. They're not interested in any other thing beyond that.
No, the investigation will be ongoing. The investigation will be ongoing until the OIC, the officer in the case, and the prosecution service certify themselves that the trail of inquiry has gone cold. Yeah.
Will they be looking at what is going on here?
Oh, yes, they will. I mean, the sentencing exercise will go beyond the UK. It will even may extend to the US. For instance, after sentencing, the judge under the criminal justice, no, under the power of the criminal court and the Criminal Justice Act 1988 has authority to make what's called confiscation order. The difference between confiscation order and forfeiture is that forfeiture is directed to a particular asset, but confiscation is directed to all the asset that the prosecution believes to have been purchased through or by criminal proceeds or proceeds of crime.
And you're saying that that order extends beyond the jurisdiction of the UK?
Yes, I mean, if it's believed that she has assets in Bulgaria, for instance, they will go for that. They will make a confiscation request to the Bulgarian authorities.
And they can make same to the Ghanaian authorities.
Because what they will do is that they will draft a schedule of benefits. They will say, look, we believe that you've been drug dealing for X amount of period, and you've made this benefit. You have benefited, X.
Is that not the more reason why she will not be interested in revealing more than simply pleading guilty and keeping mute and going to jail?
Well, again, whether you remain mute or go to trial and you're found guilty or you plead guilty, there will still be an issue of confiscation to be dealt with. So once the benefit has been drawn up and there's a list of realizable assets, they will say, look, we want you to pay for this, and then the assets will be confiscated in order to finance or to pay for the benefit. So if she has assets here, they will go for it, or the British will come for it.
I see.
Yeah.
Okay. Real. Thank you very much. Maybe a very last question that I was thinking about asking. Here in Ghana, the Minister for Foreign Affairs, for example, has spoken about the fact that she had told Ghana's mission ahead of time that, look, the money in this was lucrative, and so she was bent on doing this business. She was going to plead guilty and go in for it. You are still saying that this information the prosecution will not use, and therefore there will be some mitigation that will go to have any effect?
No, all I'm simply saying is that that information will obviously be at the back of the mind of the prosecution.
They will use it.
Preparing for the sentencing exercise. And it will also be used by her defense. But the prosecution will be countering that to say that she is not, what she's saying indirectly is that she was a mule. And she's not a mule because mules do not normally have large assets or businessmen or businesswomen. They're normally economically challenged, and they're doing it for a very small amount of reward.
She says that she thought it was gold.
That I haven't heard of. That I haven't heard of.
That's what we have been told by the mission.
Right.
That's what she told them.
All right. From my experience, the moment a significant comment is made that I thought I was carrying this, that amounts to a defense. So hence, that's why I'm surprised. That's why I always say to you that once a significant statement is made, we all have it at the back of our mind that there's going to be a defense, and then halfway or somewhere down the line, it changes to a guilty plea. Because obviously, she's denying knowledge, which is very significant. So that amounts to defense. So if we were to follow the normal course of process, we should be pushing to trial.
Knowing what you know, if you were her lawyer, would you have asked her to plead guilty?
I will basically, as a defense lawyer, my role would be to allude her to the pros and cons of going for a trial and pleading guilty. And I will leave it to her to decide. And if the roles were reversed as a prosecutor, I'll simply look at the evidence, look at the rules, and apply the rules.
All right. Thank you very much. Kuku and Co, you've been listening. You have a question for him? Any question for him? Okay.
I just wanted to find out from the explanation, for example. So when the Ghana High Commissioner decided to visit her, will you say that she requested, or you asked that question?
Sorry, I understand we have a problem with your microphone, but did you understand the question he was seeking to ask you?
Yes, I do.
What's your response?
Understand. My response is that I wasn't there, and it's very difficult for me to answer that. But safe to say that that request is available to her, and also the visit is also available to the Commission. It's perfectly normal.
Right.
If you are, but what, I mean, from my experience, either she requested or the mission got to know about it. How the mission may have got to know about her, I simply don't know. All I can say is that from decades of dealing in such cases, most of my clients, as a defense lawyer, always come through a member of the family or from somebody, and never from the mission. And as a prosecutor, I've never had access to that information as to how the person, the detained person, got in touch with a lawyer.
How much do you know, finally, very finally really, how much do you know this process, the mistrust that has arisen as a result of this, how much do you know it will impact negatively on the collaboration between the British authorities and the Ghanaian, drug enforcement, agency in seeking to fight this drug trade? I'm sure you may be aware by now that we are told that she came on the NACOB, radar in 2009 when some, was it a 5 kg of cocaine was being smuggled, and as a result of that, there's a driver who is presently in jail. And there are those who don't believe really that she would have come on their radar since 2009, and up to today, they've had nothing to pick her up until this thing happened. How much of an impact will it make to the relationship? Because people say it's going to create a lot of mistrust between the British and the Ghanaian officials, especially now that we know some of them are being charged of being part, collusion.
I can speak from my experience in dealing with the West Indian community, if you don't mind. Now, during the 90s, well, 80s, right up to 2000, there was a lot of mistrust with vis-a-vis the British authorities and the Jamaican authorities, because they were under the impression that drug trafficking was rampant in that part of the world and there were no safeguards. Hence, a lot of Jamaicans were labeled as pushing what you term on the street as weed, or what's the other one, cannabis. And according to sources, that was the reason why they withdrew the Commonwealth, I believe it was the Commonwealth passport, because from some time ago, Jamaicans did not need a visa They actually withdrew it because of the mistrust brought about by the lapses in their security arrangement to detect drugs. The same or similar may well happen in Ghana, because obviously, I mean, how difficult is it to really detect drugs as your port of entry when leaving? It's not that really difficult. So I think it may dent or damage the
Especially
relationship.
that this one is 12K that went through, and
that's a lot.
People are being charged for abetting it.
That's a lot.
Who are officials who are supposed to have prevented it.
That's a lot.
Okay, thank you very much indeed, Godwin Ejei-Gyamfi, for joining us on Newsfile and sharing your experience with us. He's a former senior prosecutor at the Crown Prosecution Services of the United Kingdom, and he has been sharing with us some of his experience. Thank you very much indeed.
Thank you.
We'll take a break at this point. We'll return, and I'll continue with my guests here in the studio. Don't go anywhere.